Hey everyone, I'm Devin Harris. I'm going to be covering my case study is on Kaufman versus Garnett. It was a Supreme Court of Virginia ruling on January 10th, 2003. So in case you guys want to look it up. You guys can also find basically a short excerpt of it in the Law for Recreation and Sports Management 6th edition book, our book, on page 222 through 224. Alright, the basis for the court case, basically, the basis for the case stemmed from an injury sustained to a football player. The incident occurred when the 13-year-old player was attending football practice. Basically, prior to this practice, the team had lost a game, and the coach had saw that tackling skills were lacking, and when they started the practice, he also saw that tackling wasn't taking place properly. So the coach basically used the player that was eventually injured to demonstrate proper tackling fundamentals to the other players. The player was only 144 pounds, and the coach was 260 pounds. The coach instructed the player basically to hold the football and to stand still and to not move. And he basically proceeded to go through the demonstration of tackling. And he basically, from the excerpts from the case, is that he lifted the player 2 more feet off the ground and he slammed him into the ground. And then basically when he landed, he broke his humerus, which is obviously the upper bone and long bone in your arm. So obviously the initial case that was filed from the child's parents against the coach was a claim of negligence, assault, and battery against the coach, who's basically the coach's name was James Garnett. At the time when the incident happened, Garnett was an assistant coach at the Boutoncourt County School Board. And from the school board, he was responsible for the supervision, training, and instruction of all the defensive players. So basically, essentially, he was the defensive coach. And again, Andy Kaufman was a 13-year-old. He had never played football prior to this season. It was his first season ever playing. And at the time of the incident, he was the third-string defensive back. And then something else to note prior to this, none of the players during practice had ever been touched or taught proper tackling techniques when they were actually hitting each other. So something to note. During the court case, obviously the parents brought up that they had never basically gave any consent to the coaches that he could tackle their child or anything like that. And they basically, the first part of the case was they wanted to, basically they were suing him for negligence. The court, initial ruling in this, the court dismissed the plaintiff's motion for action of gross negligence. They found that he was employed by the school district, and because of this, he was immune to simple negligence. Excuse me, I misspoke. They were suing him for simple negligence. The court did say, though, there was sufficient evidence for possible assault and battery charges and gross negligence. So that moved them into the second part of the trial. In this part of the trial, the court had to listen to both sides on the basis that there was gross negligence, which was from the assault, and battery that took place. The parents claimed that they had never gave consent to the child to be tackled by the coach, and when the coach was as large as he was, that he should have known that he was going to basically cause some type of bodily harm by picking up Andy and slamming him to the ground. They also pointed out that this type of instruction had never been conducted at practice prior to this point, and that they were not informed prior to the practice taking place that this was going to obviously happen. The coach, obviously, and his lawyers basically claimed that by Andy signing up to play football, that he agreed to be tackled by both players and coaches. Obviously, you can get tackled in the game or practice by other players in your team, or players in games, and obviously the coaches need to be able to train the individuals in proper tackling techniques. And then also, basically, the injuries are part of the game, though it is his job to mitigate injuries. And there's implied risk when you sign up to play the sport, and one of the implied risks is that you can be injured. The court findings, again, for this second half, the court again agreed with the coach. Basically, when the court proceedings are over, I'll read you guys basically a short excerpt what was said from the judge. The plaintiffs agreed that they were not aware that Andy's coach would use physical force to instruct the rules and techniques of football, since neither he nor the other coach had done so in the past. Basically, this is the judge talking. He said, surely the plaintiffs are not claiming that the scope of their consent changed from day to day depending on the coach's instruction methods during prior practices. Moreover, they did not allege that they were told that the coaches would not use physical demonstration to instruct the players. Additionally, the plaintiffs did not allege that the tackle itself violated any rule or usage of the sport of football, nor did they plead that Andy could not have been tackled by a larger, physically stronger, and more experienced player during the game or practice. Tackling instruction on proper tackling techniques are aspects of the sport of football to which players consent when making the decision to participate in sport. In sum, I conclude that the plaintiffs did not sufficiently plead a claim for battery. We must remember that the acts that might give rise to a battery on a city street will not do so in the same context of the sport of football. We must also not blur the lines between gross negligence and battery, because the latter is an intentional tort. I agree fully with the plaintiffs' alleged sufficient facts to proceed with their claim for gross negligence. For these reasons, I respectfully concur in part and dissent in part, and would affirm that the judgment of the circuit court sustaining the demur with regard to the claim for battery. So basically, what the judge said, from obviously everything that we had already covered, is that basically by him signing up and his parents giving consent that he could practice, that he basically he waived his right that he could be injured when he played a sport, and that the coach was within his right to obviously perform the tackle on him. However, you know, that kind of threw out the part where that he could be charged with any type of assault or battery. But they did say that he was negligent, and he had gross negligence in the fact that he knew how much bigger he was than Andy, and that they could follow on and you know take another trial up for gross negligence because he did injure Andy. And going back, another part of that I thought was interesting, that the judge wanted to point out that you don't want to blur the lines between gross negligence and battery, because the latter is an intentional tort. So basically, by him saying the difference between gross negligence and battery is gross obviously means like you should have known better, you made a mistake, and something bad happened. Unlike battery, where it's you had the mindset, I was going to go in there, and it was an intentional act where I'm going to go here, I'm going to pick this kid up, I'm going to slam him to the ground, I'm going to break his arm to show all the other kids, this is how you tackle, or this is how you should tackle. And that wasn't the case from the judge's eyes and from the court's eyes. That coach didn't have that. That wasn't his purpose. So yeah, that's basically everything for this case. If you guys have any questions, I'm looking forward to hearing them. Thanks.